It is now 10 o'clock on January the 14th, 2014. I would like to call the order of the Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Mosby, will you please call the roll?
Robert Helms.
Present.
Wayne Hinkle.
Here.
David Neal.
Here.
W.T. Patterson. Jane Gay Sowell.
Here.
Robert Starkey.
Here.
Anita Taylor. Mr. President, we have 5 board members accounted for.
Thank you. We'd like to now welcome our new board member, Robert Helms. I think Robert knows everybody here, and we all know Robert and have known him for years, and we welcome him to the board. We know he will be a fine member to this board.
Thank you.
So, we next will adopt the agenda for the meeting.
Motion to adopt the agenda for the meeting.
Have a motion from Mr. Hinkle, second by Ms. Jane Gray Sowell. All in favor?
Aye.
Any opposed? The agenda is adopted. We now approve the minutes, review and approve the minutes from the December 10, 2013 board meeting.
Mr. President, we should have those ready for you for the next meeting because of the longer board meeting and then the teleconference and some things we want to still review those a little bit before we present them to you.
That'll be fine. All right. Next, every year we kind of talk about the procedures for the new board or the past board members and the new board member. And we generally use adoption of the Robert's Rules of Order for the board members. Is there any discussion on that?
Chairman, I move to approve the use of Robert's Rules of Order for the board meetings of the Tennessee Funeral and Embalmers Association.
Second.
Have a recommendation, Ms. Sowell, and a second. Ms. Neal, all in favor?
Aye.
Motion carries. Ms. Mosby, will you sign in, Ms. Taylor, please?
Yes.
Thank you. The next will be our conflict of interest statement. We will need these if you will review them at some time, and at the end of the meeting, we will ask each board member to sign and turn in to Ms. Mosby. We'll continue on next to the legal report by Benton McDonough, Assistant General Counsel.
Thank you, Mr. President. The first complaint is complaint number 2013-02-3331. The second complaint is number 2013-02-3332. In this case, the funeral establishment's license was first issued on March 14th, 2001, and the respondent in this case was one of 2 members of the limited liability company, the registered agent for the LLC, and served as the managing funeral director from May 12, 2003 until the establishment was sold on December 17, 2012. Under Tennessee Code 625412, it requires an audit report prepared and signed by an independent CPA in order to transfer a pre-need seller registration to a new owner. The respondent in this case engaged the services of a local CPA to determine the establishment's compliance with certain provisions of the law which could have direct and material effect on the determination of the schedule or pre-need funeral contract amounts. The CPA found violations of 625407, which requires any pre-need seller to deposit funds collected on the sale of such contract and shall deposit the funds in a trust account or paid to an insurance provider within 15 days. Numerous signed contracts were discovered that were not listed on any insurance company confirmations, nor were any trust fund accounts found to exist. CPA found violations of 625409C, which prohibits discounts as well. In response to the pre-need funeral contracts, the respondent states that as for the audit, the new ownership mistakenly provided the pre-need and at-need contracts instead of just the pre-need files to the CPA for the audit. Respondent states that the money was not trusted, nor were the contracts listed with the insurance companies because the families made partial payments to the pre-need contracts and never returned the complete contract. As far as the discounts go, the respondent states that they were told by burial service auditors that they could not provide discounts to customers. However, the respondent believed it was okay to call it a competitive pricing on the contracts instead. The respondent started using a new accountant, and they used documents that had a box for discounts on the contracts, which the respondent marked. When their personal auditor reviewed the documents, the respondent states that the auditor had them mark through the term discount and replace it with competitive pricing. The only time the respondent used competitive pricing was if a customer brought in a flyer or documented pricing from another funeral establishment. We found no history of prior complaints for Respondent 1 or Respondent 2. For Respondent 1, we're recommending a consent order with a $1,000 civil penalty and suspend the funeral director's license for 1 year and require a total of 10 additional hours of continuing education, 4 of which must be made in ethics. And for Respondent 2, we're recommending that that we suspend the embalmer's license for 1 year and require a total of 10 additional hours of continuing education, 4 of which must be in ethics.
Motion to accept council's recommendation.
Second.
Have a motion from Mr. Hinkle and a second from Mr. Helms. All in favor?
May I have a question?
Or question?
I'm in agreement with the recommendation. However, I wonder why it is so much more an appropriate disciplinary action than we've had in the recent past for some same such violations.
Well, we believe, given the facts in this case, that this was the appropriate action for this
I
matter.
agree, but this is far and above more appropriate than action that's been being recommended in recent cases that are similar to this. Is there change of the water or something?
No, ma'am. We just felt like this was the appropriate need in this
Okay.
the circumstance. I don't have an
This
explanation
is
as to why
indeed
it's
appropriate, in my opinion. That satisfied my question.
All right. I have a motion on the floor and second. All in favor? Excuse me.
Do they have offer for hearing or anything?
That's what the consent order is in this case. They'll get a consent order with the $1,000 civil penalty and then the suspension of the license. So I'll put both of these on one consent order.
Okay. And so they have,
Chance for a hearing.
Yeah, yes, sir. They'll have a chance for a hearing. We'll offer this to them in a consent order, and if they agree with it, then they can sign it. Or if they don't, then they can go to a formal hearing at that point.
okay. That was just something that I noticed wasn't on the end of this, but,
Right.
yeah.
The term competitive pricing, that's not acceptable either. That's a discount, isn't it?
We think that's just an end around to providing discounts.
Yeah, so I mean, that's not legal to use that on your contract.
No, no, it is not. No, sir. And actually, if the board would like to add on there, a formal hearing at the end of that, then I think that would be appropriate in this case, just to make sure that we cover all our bases on it.
Make a motion, we add that to the end of it.
Second it.
I have a motion from Mr. Neal to add to the recommendation, and a second from Mr. Hinkle. All in favor?
Aye.
Motion carries.
That would be authorization for a hearing.
Correct.
Yeah,
Okay.
correct. Yeah.
Okay. Number 3 is case 2013-0222271. On October 4th, 2013, a field representative conducted a routine inspection of the respondent establishment. The current license and latest inspection report of the crematory utilized by this establishment was not available for inspection. The ventilation fan in the embalming room was not working and must be repaired. The current funeral director's license for one individual was not available for inspection, and the current embalmer's license for one individual was not available for inspection either. 4 files lacked a cremation authorization form signed and dated by a licensed funeral director. The establishment's cremation authorization form must be changed to read 180 days instead of 60 days for unclaimed cremated remains. And on the general price list under direct cremation with wood casket or cremation container, the price range of $3,480 being offered to the consumer is inconsistent with the casket price list, as there is no listing for a wood casket or cremation container on the casket price list for that price. In response, the respondent states that an expired license for the crematory was hanging on the wall during the inspection, and that the respondent immediately called the crematory to obtain a copy of the current license and latest inspection report in the presence of the field representative. Respondent believes that the fan in the preparation room was working properly and that he had just had the switch in the wrong position when the field representative tested it. Respondent states that they contacted a service company who found that it was in good working condition. The funeral director and embalmer in question, whose licenses were expired, has not worked for the respondent in 2 years, and their licenses should have been removed from the wall prior to the inspection. As for the wording on the cremation authorization form, it has been changed to read 180 days, and the general price list has been corrected to reflect a correct price range for cremation with wood casket. We found a history of 5 closed complaints in this matter, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
I have a motion from Mr. Hinkle and a second by Ms. Taylor to accept council's recommendation. All in favor?
Aye.
Motion carries.
Number 4. Number 4 is case 2013-022-301. On October 9th, 2013, a field representative conducted a routine inspection of the respondent establishment. It was determined that the respondent failed to provide a copy of the current license and latest inspection report for the crematories utilized by this establishment. In response, the respondent apologizes for not providing a copy of the current license and latest inspection report of the crematory, and they state that they emailed the crematory in January but never received a return confirmation. We found a history of 2 closed complaints and 1 open complaint in this matter, and we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
I have a motion from Mr. Hinkle and a second by Mr. Neal to accept council's recommendation. All in favor?
Aye.
Motion carries.
Number 5 is case 2013-023821. On November 15th, 2013, a field representative conducted a routine inspection of the respondent establishment. The establishment advertised in the local newspaper as the Funeral Home and Cremation Services, reflecting a name that is used other than that which is listed on the application with the funeral board. Also, the preparation room was found to be in need of a general overall cleaning, and the reason for embalming must be completed on the statements of funeral goods and services selected. Also, merchandise and services must be completed on all statements of funeral goods and services selected, as the description should be such that the consumer can easily compare the prices on the contract with the appropriate price list for accuracy. One file that was reviewed had pricing errors. A charge of $3,895 was charged for an unidentified casket. The outer burial container selected was a Polyvault, listed on the casket price list at a price of $1,195. But on the statement of funeral goods and services selected, the family was charged $1,395, which brings an overcharge of $200. And on the general price list, the alternative container listed on the general price list must be changed from fiberboard to cardboard to agree with the disclosure on the general price list and the casket price list. In response, respondent states that the manager suffered a serious car accident on June 8, 2012, leading to neck and knee injuries. The same person later suffered a stroke on February 2, 2013, leading to another licensed funeral director taking over the day-to-day activities at the funeral home. On September 30th, 2013, the manager was airlifted to a local hospital with congestive heart failure. As for the name change, the respondent did not intend to give the appearance of a name change in the newspaper, and this matter was addressed and changed immediately. As for the preparation room, there were no soiled or contaminated surfaces, instruments, tables, fixtures, or equipment, clothing, linens, or waste present at the time of the inspection. But there was a deceased body on the table that had just been embalmed, but nothing visibly contaminated. As for the reason for embalming, respondent states that the reason for embalming was not listed due to a simple oversight on the part of the funeral director. The casket description was not given due to oversight on the part of the funeral director, who did not go back and fill in the description when the final casket was decided upon. Also, the casket ordered was an oversized unit that had to be ordered on short notice and was not large enough when delivered, so it had to be returned. As for the pricing error, respondent states that there's no pricing error that existed for the outer burial container purchase, as it simply was not listed as an oversized Polyvault, which was a funeral director error. And as for the general price list, respondent states that the general price list was corrected immediately to read cardboard instead of fiberboard under alternative container. We found a history of 3 closed complaints in this matter, and we're recommending a consent order with a $750 civil penalty and authorization for a hearing with instructions that they refund the $200 overcharged to the family.
Move to accept the recommendation.
Second.
Second.
I have a question on the overcharge to the family. That was because they had to get an oversized container, which might not be listed on a general price list. Would that not be?
Well, our field representatives can only operate with the documents that are provided by the funeral establishment. So based upon the documents that were provided to the field representative and the contracts that were reviewed, it was determined that there was a $200 overcharge in this case. And, whether or not it was an oversight on the part of the funeral director to make that clear in the contract, I think that is that's up to them to make sure that that's taken care of before the field representative comes and reviews the records. So, what we typically do is in the cover letter will be to instruct them that they should return the $200 overcharge to the family, but we also don't have the authority necessarily to make that happen. We can just recommend that they do that. So,
It's a goodwill gesture.
Yes, ma'am. If we find that there, if we have proof that there is an overcharge, then we'll always put that in the letter that they should try to make things right and return the money. But ultimately, it's up to them and the family that was overcharged to determine whether or not that's going to happen.
Have a motion from Ms. Sal, second by Ms. Taylor. All in favor?
Aye.
Aye.
Motion carries.
Number 6 is case 2013-024-291. On November 22nd, 2013, a field representative conducted a routine inspection of the respondent establishment. The consumer's right of selection disclosure was not exact and word for word on the general price list as required by law. Also, the basic services disclosure was not exact and word for word on the general price list. And the direct cremation disclosure was not exact and word for word as required by law. Also, the immediate burial upper end price range was incorrect when compared to the price of caskets offered for sale on the casket price list. Also, immediate burial with container upper end price range and lower end price range was incorrect when compared to the price of caskets offered for sale on the casket price list. The direct cremation upper end price range was incorrect when compared to the price of caskets on the casket price list. And the direct cremation with cremation casket selected from funeral home lower end price range and upper end price range were incorrect when compared with the price of caskets offered for sale on the casket price list. As for the casket price list, 2 caskets on the casket price list contained an incorrect price when compared to the price of the same 2 caskets offered for sale in the casket selection room. The Woodridge pecan offered for sale at $5,588 in the casket selection room was not listed on the casket price list. The following 3 alternative containers offered for sale under direct cremation options on the general price list were not listed on the casket price list as required by the FTC's funeral rule, and those were the minimum cardboard alternative container, the standard brown alternative container, and the Stratus alternative container. Also, the respondent failed to respond within the time specified upon receiving notice that a complaint was initiated against their establishment license. Therefore, we received no response in this case, and we found a history of 6 closed complaints. And we're recommending a consent order with a $500 civil penalty plus $250 for no response for a total civil penalty of $750 and authorization for a hearing.
Move to accept the recommendation.
Second.
Have a motion from Ms. Sal and a second by Mr. Neal. All in favor?
Aye.
Motion carries.
Number 7 is case 201302491. The complainant's daughter was killed in a car accident on October 9th, 2011. The family asked that donations be made toward the $8,400 funeral bill in lieu of flowers. The local district attorney filed a request for the criminal victim's rights as the complainant's daughter was killed by a drunk driver. The money from that fund would be used to pay for the funeral expenses. The complainant states that the respondent has filed suit against her seeking the remainder of the funeral bill. The complainant believes that the respondent is asking for more money than they are actually due and that they have not taken into account the money from the funeral fund. The complainant would like to know where the funeral fund money wound up. In response, the respondent states that a contract was entered into by the establishment, the mother, the father, and the biological father to cover the funeral expenses. On March 18th, 2012, a letter was mailed to the mother showing a balance due of $8,063.23 and that no payments had been received since October of 2011. The respondent gave them until April 15th of 2012 to provide payment and received no response to that letter. The mother came in on July 6, 2012 and made a payment of $100 towards the fund. The mother was contacted again on August 27, 2012 for her to pay the remaining amount, and the respondent received no response in that case. On September 4, 2012, the respondent received a letter from the mother involving 5 post-dated checks stating that she was in the process of obtaining a loan and that she had filed suit against the insurance company of the other driver. On August 28, 2012, the father came in and paid his part of $2,687.74. Next, the biological father came in and paid $500 in 4 separate payments totaling $2,000. However, 2 of those checks were returned as insufficient funds, which respondent received a judgment against on December 7th of 2012. As of January 4th, 2013, no payments were made with a balance remaining of $3,775.49. The original contract was for $8,968.23. With the community payments towards the funeral fund of $905, the payment so far by the mother of $600, the return funds for insufficient funds of $1,000, and the payment by the father of $2,687.74 is the update on this case. And the respondent states that there's an interest of 5.25% as of December 7th, 2012, plus court costs against the biological father. As of January of 2014, a warrant has been issued for the mother and biological father for non-payment and to appear in Scott County General Sessions Court with a court date of January 17th, 2014. We found a history of 2 closed complaints in this case, and we're recommending that this case be dismissed as a civil court appears to be the appropriate venue for this matter.
Motion to accept.
Have a motion by Mr. Hinkle and Ms. Taylor, and a second by Mr. Helms. All in favor?
Aye.
Motion carries.
Number 8 is case 2012019321, and number 9 is case 2012019322. On the cases from this point forward are cases that were presented at prior board meetings, and we're recommending that they be closed. But for the record, I will read the cases into the record, and then let the board decide at that point.
Now, is that just these two, or from here to the end?
From here to the end.
Okay.
So this case was originally open in burial services. However, the case was closed against the pre-need sales agent and reopened against his funeral directors and embalmer's license. On February 27th, 2012, an auditor with burial services conducted a routine audit of the respondent establishment. There's no record that the 2010 establishment pre-need funeral funds report on irrevocable and revocable contracts was received in burial services. Also, it was determined that the statistics reported in Section 5 of the 2009 establishment pre-need funeral funds report was incorrect. The number of insurance pre-need contracts written during 2009 was reported as 6. However, there are only 5 documented pre-need contracts on the Investors Heritage insurance listing. Furthermore, there were 11 serviced pre-need contracts reported online D, but records showed only 5 were serviced. This was a repeat finding in this case. And also during the review of the funeral home files, there's evidence of continued insufficient documentation in pre-need contract files, as it was noted that of the 4 files that did not contain the enrollment and contract application form, which shows the beneficiary information, contract amount, and application date, the following was shown. George Orr was deceased. No evidence of enrollment form was presented during the exam. Also, Laura Orr has an active file and no evidence that enrollment form or contract is in the file. And as for exam fees, the funeral home pre-need examination was performed on August 9th, 2010, and as of the date of the audit report, burial services has yet to receive the $300 exam fee. We never received any response in this case, and the respondent allowed both his funeral director's license and embalmer's license to expire on June 30th of 2012. There was a history of several complaints, and we're recommending that these cases be closed as the respondent's license is expired and he is unlikely to apply for a new license.
Motion to accept council's recommendation.
Question. If he does, reapply, what will the circumstances be at that point?
He'll have to come back before the board. At that point, we'll
We'll have to reappear.
right. Yes,
And what
ma'am.
about examination
Um,
for certification? Excuse me.
do you know about that?
You'd be required to take a Tennessee Laws and Rules examination, and the board might have authority or leeway to require him to take even further examinations. I'm not sure. I think it's, this gentleman owned the business. He sold the business. His license, his funeral director and embalmer's license have expired. I think he's probably finished in funeral service, would be my guess.
But again, if he ever decided to try to get his license back, he'd have to come from the board, and all these facts would be presented then.
Correct.
Okay.
Have a motion for Ms. Taylor and a second by Mr. Helms. All in favor?
Aye.
Motion carries.
Number 10 is case 2012001061, and number 11 is case 2012001062. Number 12 is case 2012001063. The complainant sold products to the respondent in good faith, and the products have yet to be paid for. On September 28th, 2011, the complainant sent a letter to the respondents with an invoice for the past due products. Additionally, the complainant provided a copy of a check that was provided by the respondents and returned by the bank as not sufficient funds from October 2011. The complainant points out in the letter that the respondents were aware that the complainant would seek remedies through the state board should the invoice not be paid. And the complainant states that letters and phone calls went unreturned and ignored by the respondents, with the exception of the check returned by the bank. We never received any response from the respondent in this case. There was a history of one closed complaint, one open complaint against the establishment that were not related to this. And we originally recommended a consent order with a $750 civil penalty and $250 for no response, for a total civil penalty of $1,000 and authorization for a hearing. The new recommendation is that this establishment is no longer owned by the same entity, and therefore we recommend that the complaint be closed. And furthermore, the complainant also provided confirmation that this matter has been resolved and addressed by the respondent.
Motion to accept.
Second.
I have a motion from Ms. Taylor and a second from Mr. Hinkle. All in favor?
Aye.
Aye.
Motion carries.
Number 13 is case 2012-01051. The decedent in this case was removed from a local hospital by a removal service. The complainant states that the facilities were unclean, the respondent was unprofessional, a bloody sheet was haphazardly thrown over the body, and the decedent's feet were hanging off the table. They found dried blood in both ears and appeared in the ears on the day of the funeral. The parking attendant ran the complainant's car into the back of another car, and the complainant states that she and her family have suffered mentally and physically from this experience. The decedent's husband was given an unsigned copy of the bill, and the family did not receive the casket they chose. Also, the family asked for a steel vault and received a concrete vault instead. And also, the family was charged for a flower van and had no flowers to take to the graveside. We received no response in this case. We found a history of 2 open complaints and 1 closed complaint, none related, and we originally recommended a consent order with a $1,000 civil penalty plus $250 for no response, for a total civil penalty of $1,250 and authorization for a hearing. However, the new recommendation is that this is the same respondent as in the previous complaint. Again, due to the establishment no longer being owned by the same entity as it was when the complaint was filed, we believe the proper course of action would be to close this complaint at this time.
Motion to accept.
Second.
Have a motion from Mr. Helms and a second by Ms. Taylor. All in favor?
Aye.
Aye.
Motion carries.
Let me ask a question.
Question?
It's a legal question. Does this family have anything they can do other than maybe just go to court and sue the other people? I mean, can they still do that?
I would.
I mean, for any restitution for,
I mean, they would have that right.
that's their alternative.
Yes, ma'am. But it would depend on the statute of limitations as to, you know, how much time they have to file that claim. So
Question was called after the vote. Does the vote stand?
Yep.
Okay.
yes. Number 14 is case 2012-003051. On January 22nd, 2012, a field representative conducted a routine inspection of the respondent establishment. The respondent's funeral establishment license expired on November 30th, 2011, and was not renewed at the time that this inspection took place in January. During this time, the establishment conducted 5 funeral services. Also, it was determined that the ventilation fan in the preparation room was inoperable at the time of inspection. Respondent states that all of the issues in the complaint have been addressed. We found a history of 9 closed complaints, 2 of those related. We originally recommended a consent order with a $750 civil penalty and authorization for a hearing. And due to this respondent establishment no longer operating, we believe the proper course of action is to close the complaint.
Motion to accept.
Second.
Have a motion from Ms. Taylor and a second by Mr. Neal. All in favor?
Aye.
Motion carries.
Number 15 is case 2013004201. This is the same respondent as in number 14. The complainant's mother died on January 30th, 2013 in Louisville, Kentucky, and he contacted the respondent funeral establishment to handle the services in Tennessee. The complainant spoke with the respondent regarding removing the decedent back to Tennessee and burial at a local veterans cemetery. The respondent provided a charge of $100 for removal plus $1.75 per mile. The complainant stated that he would be in town the next week to make final arrangements. The complainant arrived on February 6, 2013 and met the funeral director and delivered clothes for his mother during that time. The respondent gave a price of $6,195 for the services selected by the complainant, but the complainant decided to go with another funeral home for a third of the price. The respondent provided charges of $2,053 for services already rendered before the body could be transferred to the new establishment. The complainant acquired the funds, but the funeral director, other staff, and owners of the establishment said that they were not responsible for making such arrangements. The complainant decided to contact police because he was unable to get a response from the respondent and believed that they were holding his mother's body. The complainant informed respondent of his contact with the police and informed them that he was going to proceed with a memorial service for his mother if the respondent failed to release the body. And this was 11 days after taking possession of the body. The complainant then met with the funeral director and a secretary who provided a bill that included $1,295 for services provided by the funeral director and staff and $758 for transporting the body from Louisville. In response, the respondent states that they removed the body and received permission to embalm the decedent's body. On February 7th, 2013, a funeral director met with the complainant and presented him with the embalming authorization form and the general price list. The complainant gave vital information and funeral service particulars and then looked through the casket catalog. The complainant had picked a casket of his choice and color and selected an outer burial container after he had finished. The office manager typed up the bill, which was signed by the complainant and the funeral director. The respondent explained that they do not accept out-of-state checks, credit cards, or term payments, and that the bill must be paid in full prior to funeral services. The complainant left and stated that he would return with the funds, so the respondent ordered the merchandise and a plot at the local veterans cemetery. Several days passed without any communication from the complainant, so the respondent contacted him and learned that he chose a different funeral establishment. The respondent then canceled the merchandise and the plot, but provided charges for the services already rendered, which included housing the decedent's remains. The bill provided to the complainant did not include charges for burial, but only charges for services rendered by the establishment. We found a history of 1 open complaint and 9 closed complaints in this matter. Originally, we recommended a consent order with a $750 civil penalty and authorization for a hearing. The new recommendation is that this is the same respondent as the previous complaint. Again, due to the fact that the respondent establishment is no longer in operation, we believe that the proper course of action is to close this complaint.
Motion we accept.
Second.
Have a motion from Mr. Neal and a second by Mr. Helms. All in favor?
Aye.
Motion carries.
Number 16 is case 2011020821. On June 29th, 2011, a field representative conducted a routine inspection of the respondent establishment. The respondent's establishment license expired on April 30th of 2011, and it was not renewed until June 6th of 2011. During this time, the respondent was found to have conducted 5 funeral services on an expired license. In response, the respondent states that it was the administrator's job to renew the license prior to the expiration date. The respondent states that the administrator stated on April 18th of 2011 that the license renewal had been processed and mailed. However, it was brought to the respondent's attention at that time that, to the respondent's attention on June 2nd, 2011, that this information was indeed false. We found a history in this case of 1 closed complaint with varying TCA violations. We initially recommended a consent order with a $1,000 civil penalty and authorization for a hearing. And in this case, this establishment recently ceased operation, and therefore we believe that the best course of action is to close this complaint.
Motion to accept.
Second.
Have a motion from Ms. Sile and a second by Mr. Hinkle. All in favor? Oh, excuse me. I have a motion from Ms. Taylor and a second from Mr. Hinkle. All in favor?
Aye.
Motion carries.
Number 17 is case 2013-000571. On May 14th, 2012, a field representative conducted a routine inspection of the respondent establishment. The co-owner of the establishment had their name listed as co-owner on establishment material without indicating that they were actually unlicensed. Also, the establishment name listed on the establishment application is different than that advertised on vehicles, websites, and memorial folders. As for the general price list, it was determined that the casket price range was incorrect when compared to the casket price list. The outer barrel container price range was incorrect compared to price of outer barrel container price list. Immediate burial with Gemini 20 gauge non-sealer was not listed on the casket price list. The direct cremation must include a price range, and the direct cremation with corrugated cardboard container price was incorrect compared to the casket price list. Also on the statement of funeral goods and services selected, one customer chose memorial with cremation arrangements. She was charged $1,995 for basic services of funeral director and staff, and $250 for transfer of remains to the funeral home, both of which were already included in the package, creating an overcharge of $2,245 in this case. Also, one customer chose memorial with cremation arrangements. This individual was charged $1,995 for basic services of funeral director and staff, which was already included in the package. The staff also charged for corrugated cardboard container and rental casket. Rental casket includes the charge of the insert, creating an overcharge of $2,245, but the respondent waived $823.12, leaving an overcharge total of $1,421.88. Also, another customer chose the funeral with cremation arrangements and was charged $1,995 for basic services of funeral director and staff, which was already included in the package. Also, the respondent charged for corrugated cardboard container, an additional charge for rental casket. The respondent charged the family $250 for transfer of remains to funeral home. All of this resulted in an overcharge of $2,697 with a discount of $2,200, leaving a net overcharge of $497 in this case. And also, one statement of funeral goods and services selected failed to provide a reason for embalming when a fee was charged for that service. We received no response in this case, and we found a history of one open complaint and one closed complaint. The original recommendation was for a consent order with a $3,000 civil penalty and authorization for a hearing. The board agreed to a consent order with a $3,000 civil penalty plus $250 for no response, for a total civil penalty of $3,250, and also an advisory statement that the respondent should refund the money to those consumers. And the new recommendation is that this is the same respondent as the previous complaint, and due to the business ceasing operation, we believe that the best course of action is to close this complaint.
Question.
Mhm.
How long had this firm been in operation?
First complaint there that in the history was 2009, so it was probably about that time when it came into existence.
Motion to accept.
Second.
Have a motion from Ms. Taylor and a second from Mr. Helms. All in favor?
Aye.
Aye.
Motion carries.
Number 18 is case 2013-009951. On May 21st, 2013, a field representative attempted to conduct a routine inspection of the respondent establishment. The most recent inspection had been conducted on this establishment on May 14th of 2012 previously. Upon attempting to enter the establishment, the field representative found the front entrance of the establishment locked with a sign which read Tennessee State Government Seizure, property seized for non-payment of Tennessee state taxes. And the field representative found additional signs posted around the establishment, including one sign found posted on the establishment hearse that was parked under a carport. Also, the field representative called a number listed on the signage and spoke to an employee with the Department of Revenue with knowledge of the situation. The employee informed the field representative that no human remains were found in the establishment at the time of the seizure, and that the field representative took additional pictures and completed their report in this case. We received no response from the respondent in this case, and we found a history of one closed complaint, one dismissed complaint, and 2 open complaints. The initial recommendation was a consent order with a $500 civil penalty plus $250 for no response, for a total civil penalty of $750 and authorization for a hearing. This is the same respondent as the 2 previous complaints. Therefore, we similarly believe that the best course of action in this case would be to close the complaint due to the respondent establishment ceasing operation at this time.
Make a motion, we accept council recommendation.
Second.
Have a motion from Mr. Neal and a second from Mr. Hinkle. All in favor?
Aye.
Motion carries.
Number 19 is case 2013-017961. On August 2nd, 2013, a field representative conducted a routine inspection of the respondent establishment. The funeral establishment license expired on April 30th of 2013. It was not renewed until June 28th of 2013. From May 1st, 2013 through June 27th, 2013, the respondent arranged and or conducted funeral or cremation arrangements for 8 deceased individuals. Also, we determined that the direct cremation with alternative container must be included on the general price list as required by the FTC. We received no response in this case, and we found a history of 1 closed complaint, 1 dismissed complaint, and 3 open complaints. Originally, we recommended a consent order with a $1,000 civil penalty plus $250 for no response, for a total civil penalty of $1,250 and authorization for a hearing. However, this is the same respondent as 3 previous complaints, and therefore we believe that the proper course of action would be to close the complaint at this time due to the respondent establishment ceasing operation.
Motion to accept.
Second.
Have a motion from Mr. Helms and a second by Mr. Neal. All in favor?
Aye.
Motion carries.
Could I ask a question?
Yes.
Is this the way we get around some of this enforcement, is we just cease operation?
Well,
I mean, we've never had this many in a row, but it's the same individuals.
right.
Yeah.
Well, they obviously had several complaints
Yeah.
filed against them, but in the event that they tried to reopen the business, then
Okay, if somebody tried to reopen the business under a different ownership, that's not an issue.
right.
But if this individual tried to open another establishment, this would be an issue, correct?
Yes, sir.
Okay.
This individual have a license that's still valid?
Based on the information that we had in that previous complaint, they do have a valid establishment license because they renewed it in June. So it's
Individuals have license?
yes, ma'am. That's my understanding, but obviously I would hope that they would have a funeral director's license, but I don't have that information in front of me at this time.
Based on this history, the history of this establishment and its non-compliance and non-response, can that establishment license be administratively revoked?
I would think that it could not be revoked. Are you asking by Mr. Gribble if he could?
Well, no, I mean by the department.
Well, I think the board obviously has jurisdiction over his license, over the establishment license. So if he were to try and open an establishment under that license, then the board would have authority to take action.
There'd have to be a licensed funeral director as a manager, so, it would have to, we would think it would come before the board.
Right, yes, yes, sir.
That hasn't seemed to have been, be a consideration. That was just a question.
That's the reason I said we would think it would come before the board.
Just go out of business.
That completes your report?
Yes, sir.
Okay. All right, thank you, Mr. McDonough. The next on our agenda would be administrative matters by Robert Grable, our Executive Director.
Thank you, Mr. President. The first thing is a legislative update. The second session of the 108th General Assembly convened again today, and these are the bills that have been introduced that affect Tennessee Code Annotated Title 62, which is directly the Board of Funeral Directors and Embalmers. Three of these bills were introduced last year. They carry over to this year. One is a new bill that was introduced recently. House Bill 1380, as introduced, codifies requirements for the inspection of funeral establishments presently enforced pursuant to board rules, authorizes unannounced inspections of establishments by a licensed funeral director and embalmer acting on behalf of the board. House Bill 0250, Funeral Directors and Embalmers, as introduced, prohibits certain licensees in funeral services industry from affiliating or engaging in other arrangements with certain healthcare institutions and organizations. House Bill 1125, as introduced, allows the disposal of a dead human body through the process of alkaline hydrolysis. And the last one is Senate Bill 1253, as introduced, creates a process whereby the cremated remains of certain veterans and veterans' spouses may be interred by an entity selected by the county legislative body if certain conditions are met. So those are the bills that we know of, and again, they reconvened today, so there may have been some bills that were introduced yesterday or today that we're unaware of. But for current information, there's a link there that you can go to which if you just look on the General Assembly website, anytime you can search by the word funeral, or you can look up a specific House bill or Senate bill.
Would you mind repeating that first one you read?
It's House Bill 1380.
Just repeat what you had read, if you would.
Okay. As introduced, codifies requirements for the inspection of funeral establishments presently enforced pursuant to board rules. Authorizes unannounced inspections of establishments by a licensed funeral director and embalmer acting on behalf of the board. What this is a bill that one of the associations approached the department about over the fall, and has met and worked with the department, and it's a bill that would make it very clear as to what inspections could occur, what time they could occur, and by whom the inspections would be conducted by. In other words, this bill would require a funeral director and embalmer to be doing the inspection, which would be on behalf of the board, which would be a field rep.
Sure. Okay.
They would be doing the inspection. The hours of inspection would be between 8 a.m. and 4:30 p.m. And our Assistant General Counsel, and Mr. McDonough can speak on behalf of the legal department, but it's my understanding they believe that this would be a bill that would meet state and federal courts if it was challenged in state or federal courts.
In other words, this kind of clarifies what we already are doing, but just so there's less questions or anything.
That's correct.
Okay.
There have been field representatives in the past that were not licensed.
I'm unsure of that. Since I've been here, they've always
I
been
mean, in the past there were.
okay. There's always been licensed as a funeral director and embalmer since I've been here, but in the past there may have been unlicensed.
There were not.
And at one time, the Department of Health conducted funeral establishment inspections, if you'll recall that, many years ago. And
They have to be both a funeral director and an embalmer. in
That's
order
the
to
way
be
the
an
bill
inspector.
is
The
as
word is
written.
and, not
sir.
or.
That's the way the bill is written
Yeah.
presently.
And this, HB 0250, that is, does that relate to the problem that currently, has recently existed with, some funeral homes contacting hospices and hospice care givers and other home health care givers and encouraging them to recommend their establishment? Is that what
It's-
that relates to?
It's my understanding that that's a fair analysis of what that bill does.
And apparently our action to hold off and further investigate and discuss the alkaline hydrolysis is go ahead with it, right?
Well, it's
After
still
the
there. I don't know
presentation
that
we
it's,
had here, and
I don't know it's gonna move anywhere. It's still there. It could be moved, and that's what we were instructed
they're
to
going
do.
forward with it without our recommendation.
I do not know that. I do not know that that's gonna happen. We were
Sounds
instructed
like-
to prepare a list of bills for you that affect this board. And these are active bills, or they can be active bills. It doesn't mean there's active movement on them at the present time. There may not be any more
They're
movement.
just sitting there.
Yeah, there may not be any more movement at all than what there was when they adjourned last year, but there could be. There's a possibility there could be, and our purpose is to inform the board and make the board aware of possibilities so that something doesn't get passed and go into effect, and then the board say, we didn't know anything about this. So it's not, we're not assured that they're gonna have any movement on the alkaline and Ross's bill. May not be anything at all done, but there could be.
I haven't heard anything about this last one regarding veterans. What does this mean in turn by an entity selected by the county legislative body if certain commissions are met? Don't know anything about that?
I don't know exactly what,
You know what it indicates or what it,
I do not. You could go to the link and search the bill number and go to the bill.
that's a new one on me.
It's not, it was there last year. It's not, the only one that's been there in use since they adjourned last summer is House Bill 1380. These other three were carryover bills from the previous year. And most of you are probably aware of it and know this, but in case you don't, when a new General Assembly starts, they can carry over 1 year. But if whatever's not passed when they adjourn this time, then it has to be reintroduced as a new bill the next General Assembly, next session. Licensee report. Reports of a license is administratively approved by the Executive Director pursuant to the Board Authority for the period of December 10, 2013 through January 13, 2014. Establishments: Harrison's Memorial Chapel Incorporated in Memphis, a new establishment. Cook Campbell Mortuary Incorporated in Maynardville, an ownership and name change. Individuals: Michelle Lynn Callahan of Johnson City, a funeral director and embalmer by reciprocity. Cherry Ann Deering of Olive Branch, Mississippi, funeral director by reciprocity. And Stephen Walter Howard of Bristol, Virginia, an embalmer by reciprocity. Closed establishment report for January board meeting. There are 2 establishments that have reported closing since the last board meeting. Henry Smith Funeral Home, 335 Franklin Street in Clarksville, Tennessee, and Jackson Funeral Services, 106 Administration Road, Suite C in Oak Ridge, Tennessee. Disciplinary action report for January 14 board meeting. This is a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to the Board Authority for the period of December 1, 2013 through December 31, 2013. And those are listed. I don't see any need to read those into the record. Those are
Published anyways.
Yes, they're published each month. There's a disciplinary action report that's published. These are the same ones that were published for disciplinary action for the month of December. And lastly, we have an open complaint report to present to you. As of yesterday, there were 92 total complaints that were open. 10 of those were against either funeral directors and/or embalmers, and 82 of them were against establishments. Mr. President, I'll be glad to answer any questions. Otherwise, that completes my report.
Thank you, Mr. Gribble. Are there any questions for the executive director? All right. We'll now move on to approval of license.
Mr. President, could we get a motion to
Oh,
accept?
I make a
excuse me.
motion, we accept it.
Sorry. Motion by Mr. Neal and second by Mr. Taylor and Ms. Taylor and Mr. Helms. All in favor?
Aye.
Motion carries. Next thing on the agenda will be approval of the license applications.
Mr. President, there's one individual to appear before the board today. If you want to come up and have a seat, Mr. Plunk, if you'd like to come up, you can as well. The individual appearing today is Jasmine Penny Zervas of Alexandria, Tennessee. Her application is for a funeral director and embalmer's license. She's seeking this license, and based on the applications, the board may, among other pertinent rules and statutes, specifically examine the Tennessee Code annotated 62-5-317 and making a determination as whether the applicant meets the requirements for licensure. She had answered yes to one of the questions, which means that she would automatically appear before the board today. It was not something I could administratively approve. And she has given you detailed information regarding that particular answer, along with some accolades that she has received since she has been employed in funeral service. She has met, she's passed her national board, she's passed her both arts and science, she's passed her Tennessee laws and rules examination. Met all the requirements that we know of. Is just because we cannot administratively approve the application that she is before you today.
March of 2004 and March of 2003. What was your employment, or were you in school, or tell me what you were doing about the times that these, I understand, now, am I correct, this first instance in March 2003, you were married to Jimmy now?
Yes, sir.
Okay.
Before you answer the question, if you will, both of you identify yourselves for the record, please.
My name is Jasmine Zervis.
Jeff Plunk, I'm her immediate supervisor.
Guess what the question is at what time did you decide to get into this industry?
It was in 2010 when I first decided I wanted to do this.
Prior to that, these two misdemeanors, that was the bulk of what you had, or I guess that's the wrong way for me to word it. That's the only instance you had, the misdemeanors or anything, which you checked yes on the application.
Yes, sir.
Okay. Motion to approve.
Second.
Have a motion to approve by Mr. Hinkle, a second by Ms. Taylor. All in favor?
Aye.
Motion carries.
Congratulations.
Congratulations.
We're not as mean as you thought we was going to be. Have a safe trip home.
There are no establishments to appear before you today, Mr. President.
All right. Any other matters to come before the board? If not, do I have a motion to adjourn?
Motion, we adjourn.
Second.
Have a motion from Mr. Neal and a second by Mr. Hinkle to adjourn. All in favor?
Aye.
Meeting is adjourned.
Yeah. Are you pushing? You're just touching
Tap it.
Just tap it?
Yeah.
See,
One thing, I guess,